Is everybody back? Everything's populating back in. Welcome back. Did y'all have a nice breakout and get some inspiration there and hear some different topics, advice and stuff? We had a really nice discussion in our group. So wonderful. So thank you. Thank you for participating in that. All right, so we're going to start now the program.
Got it.
And let me introduce Lillian Soto-Meyer from the Colorado Women's Bar Association. She will be our first speaker. And we have 3 speakers tonight. So welcome, Lillian, and everybody, if you would like to welcome her, and then our other speakers. So Lillian, are you there?
Yes, I'm here. I am from the OFCCP, Department of Labor, and have a little presentation. It'll just take us 10 minutes. And I also have my colleague, Belle Kisentron. She also works in the Denver office with me.
Okay, welcome. Welcome. Well, as soon as your slideshow is up, you can just get started, and
Okay.
then you can introduce the next speaker when you are finished.
All right. Are you able to see my screen?
Yes.
Okay.
We're good.
One minute, please. Oops. Sorry about that.
Quite all right. Technology. Good.
I think I got it now. Sorry, Belkis. Oh, okay, sorry. I'm just trying to share the right one. Oh, there we go. Okay, sorry about that.
There we go.
Yeah.
Okay, fantastic.
It took a minute.
Take it away.
All right. Hi, good evening. Thank you again for inviting me. My name is Lilian Sotomayor, and my colleague is Belle Kisentron. We're compliance officers, and we belong to the Denver District Office. My presentation today will provide you with general information about our agency and our jurisdictions. Right. Next is our agenda. During today's presentation, I'll introduce you to my agency, the Office of Federal Contracts Compliance Programs, or OFCCP, and provide you with an overview of employee workplace rights under the laws that we enforce. We'll also discuss what do we do when somebody believes that they're being discriminated. This presentation will take about 10 minutes. The OFCCP is a civil rights agency under the Department of Labor. that evaluates the employment practices of companies doing businesses with the federal government to ensure they comply with equal opportunity employment requirements, and they did not engage in discriminatory that they don't engage in the discrimination based on race, color, national origin, sex, sexual orientation, gender identity, religion, disability, or veteran status. Cover federal contractors and subcontractors are also prohibited from taking discriminatory actions against employees who attempt to learn if they're victims of pay discrimination or share pay information with coworkers. So these are some of the laws that we enforce. So there's two things that we mainly do. One is compliance evaluations and complaints. The compliance evaluations are, we conduct about 1,150 evaluations a year. And we analyze companies' employment policies and practices. And anything related to hiring, outreach, recruitment, promotions, compensations, and terminations to ensure that the companies are compliant with equal employment opportunities requirements.
I see mine, boy.
OFCCP also investigates complaints of employment discriminations against federal contractors filed by applicants or employees, which can be an individual, organization, or a group on the victim's behalf. Next slide. So two of the things that we do is outreach, such as something that we're similar for us today. We try to educate the public and the laws that we enforce, and we also provide compliance assistance to contractors and subcontractors. So who is a federal contractor? Covered federal contractor is an employer doing business with the federal government through contract or subcontracts that meet certain dollar threshold or amounts. And there's three laws that we enforce. This one is the Executive Order 11246. As amended, prohibit federal contractors and subcontractors and federally assisted construction contractors and subcontracting contractors from discriminating in employment decisions on the basis of race, color, religion, sex, sexual orientation, gender identity, or national origin. So the threshold amount that I was talking earlier for the Executive Order 11246 is any contract or subcontractor of more than $10,000. There's another law called the Section 503 of the Rehabilitation Act, prohibit federal contractors and subcontractors with a contract more than $15,000 from discriminating against employees and applicants based on disability. This includes hiring, firing, pay, benefits, job assignments, promotions, laid off, training, and other employment-related activities. Employers cannot discriminate based on individuals' disability, history of disability, or perceived disability. Employees and job applicants with disability can request reasonable accommodation to perform their jobs or apply for a job. Employers must provide reasonable accommodation unless it causes significant difficulty or expense. Another law is the VEVRA, which is the Vietnam Era Veterans Readjustment Assistance Act. This law prohibits federal contractors and subcontractors from discriminating in employment decisions based on status as a protected veteran. The categories of protected veterans covered by VEVRA include recently separated veterans, disabled veterans, armed force service medal veterans, active duty wartime or campaign batch veterans. All these three laws, the 11246, Section 503, and VEVRA, have affirmative action components that require covered contractors to engage in certain activities, including outreach and recruitment, data collection, self-audits, and assessments. Federally assisted construction contractors are not required to comply with Section 503 or VEVRA, but are required to comply with 11246. what are your rights? So basic employment rights apply to all applicants or employees. Discrimination occurs when an employer treats a qualified applicant or employee less favorably based on their race, color, religion, sex, sexual orientation, gender identity, national origin, disability, or status as a protected veteran. This also includes discipline or termination for discussing or disclosing compensation. Employment discrimination can also occur through policies or procedures that have discriminatory impact on certain groups known as disparate impact. Discrimination can be against an individual or group. So what is disparate impact? Disparate impact refers to a situation where a neutral policy or practice of an employer unintentionally discriminates against members of a protected group by having disproportionate negative impact on them. This type of discrimination does not require an intent or to discriminate. An example is a policy or practice that includes imposing heavy lifting requirement for an office position that does not require lifting or requiring a high school diploma, or requiring a high school diploma for a labor position that requires heavy lifting and not technical skills. What types of complaints does OFCCP investigate? So the type of complaints that we investigate are some of the laws that we discussed earlier. Several types of employment discrimination complaints against companies doing business with federal government, including Executive Order 11246, complaint allegation, class or systemic discrimination, individual complaints alleging discrimination based on sexual orientation or gender identity, discrimination related to inquiries about compensation, all verbal complaints, all Section 503 complaints, and all retaliation and harassment complaints based on having filed or practiced in an OFCCP investigation. Both OFCCP and EEOC may have authority to investigate certain employment discrimination complaints. To eliminate duplication of effort, OFCCP typically retains and investigates several types of complaints. That is 11246 complaints alleging a class systemic discrimination, individual complaints alleging discrimination based on sexual orientation or gender identity, and or discrimination because an applicant or employee requires about discuss or disclose their compensation. All verbal complaints, Section 503, all retaliation harassments, and all this can be filed within the OFCCP. How do we file a complaint with OFCCP? So there's 3 ways. You can do it online, and I'll provide you the website later. In person, so you can go to our offices and file a form. It's called a CC form, or you can also submit it by mail. So this is our website, dol.gov, OFCCP. Anyone may contact the OFCCP with a question about interpreting the regulations, filing a complaint, or anything on that matter. The website is very self-explanatory, and it will tell you what to do next and just be as thorough as possible. There's also a toll-free phone number that I'll provide you, and they can also help you guide you through filing this complaint. And well, so we are the Denver District Office. This is our phone number. This is the help desk number that I was talking about in case you need assistance with filing the complaint, and this is our website. So if you have any questions, please ask. If you have any questions after you leave here today, you can call us, or maybe you can email me if that's easier, or you can just go to our website and go to the frequent asked questions. Thank you so much. Let me stop this presentation. Okay.
What's the phone number? What's the phone number?
Oh, sorry about that. I just I just clicked out instead of. Okay, sorry about that. So, are you seeing my screen still or no?
Can you put that last screen up for one more second?
Sure.
I just shared the phone number for the office in the chat and as well
Okay.
as our website, so you can access
It would
the
only-
phone number.
It would only let me in for audio. For the Zoom. I don't know why. I've got to go see what my phone's been doing. So I can't see a chalkboard.
Oh, the phone number is 720
Okay.
264
Mhm.
3200.
Oh, thank you so much.
Sure. And if you want to take note of the website, it's
Okay.
www.dol.gov/OFCCP.
OFCCB.
CCP.
Wait,
Yes, sir.
Perhaps you
Peter.
can put it, I'm sorry, I don't mean to interrupt, but perhaps you can just type it into the chat. That might be easier.
Yeah, I type it in the chat already.
oh, thank you very much.
Okay. So our next speaker is, I don't know the sequence. So who's coming up next?
I am.
Oh, great. All right. Well, welcome, Sonia. Thank you for, so take it away.
Wonderful. Give me 1 second here. Okay, can you all see that okay?
Yep.
Awesome. So I wanted to spend a little bit of time talking about employment benefits as we sort of wrap up this employment law series that I know the Women's Bar Association has been doing. So as Anne mentioned, my name is Sonia Chowdhury. I am an employment law attorney at Employers Council. Before I became an attorney, I actually worked in HR and benefits administration. I worked for a broker. I also have my master's in public health, where I focused on employment benefits consulting and employee health and safety in the workplace. So a lot of experience in this field before becoming an attorney, and then I work with a lot of benefits laws in my day-to-day practice. So my understanding is that all of you are employees somewhere, which is great, but some of you are also employers as well and have your own businesses. So I'm hoping today to speak to both audiences and giving the sort of high-level overview on what our benefit laws look like. Most of what I'm going to talk today is going to be focused on the federal laws, but there are some different state components as well that I'll touch on a little bit. So we have both mandatory and voluntary benefits for what an employer can offer. Thinking about mandatory benefits, I'm sure some of you, or most all of you, are familiar with things like Social Security and Medicare, that FICA that gets taken out of every paycheck. Workers' compensation is something that your employer is mandated to provide. Each state has different workers' compensation laws. So if we have specific questions in Colorado, happy to talk there, but essentially, workers' compensation providing benefits, wages, covering costs of rehabilitation and medical services when you're injured on the job. Now we have unemployment insurance. So, if you are, terminated from a position through no fault of your own, you have eligibility for unemployment. And I know Deborah's going to talk about that a little bit when she talks about sort of that end of employment relationship. And then for employers that have 50 or more employees, they are going to be mandated to offer medical insurance under the Affordable Care Act. And they also are covered by the FMLA, Family and Medical Leave Act, which the FMLA is going to provide 12 weeks of unpaid leave to care for yourself your spouse or your child for a serious health condition, or it gives 26 weeks of unpaid leave if you are taking care of a service member. So lots of different options, lots of great benefits that sort of is a standard what every workplace has to offer their employees. But then there's also a whole host of voluntary benefits. Most of us, I think, see a lot of these benefits as part of our expectation when we look at employment, but every organization is going to do this differently. And I think at the same time, it's also a really great, way for employers to differentiate themselves, cater to their specific workforce, thinking about attracting employees as well as retaining employees. So medical insurance for employers that have less than 50 is going to be voluntary, as well as dental or vision insurance and life and disability. Having tax advantaged health savings accounts. Those are going to be options for employers to offer as well. Something like an HSA or a health savings account is going to have to be tied to a high deductible health insurance plan. So if that's not something your employer offers, they're not going to be able to offer you a health savings account, but you do have some options in the marketplace to take advantage of those things as an individual. One of the other big topics that comes up in benefits is 401k, 403b, if you work for a nonprofit, or any sort of retirement plan or retirement contributions. So this can look as, employers offering, a 401k option or having some sort of employer match that goes along with it, or, supporting their employees and putting money away for, the day that they're no longer part of the workforce. We still see pensions that come up, although I will say there's fewer and fewer pension plans that are out there, but that's something important to note, having more of a defined contribution for when you retire that's managed by the employer. Whereas, 401k and other retirement plan options are going to be managed by the individual. So those are kind of some of the more standard, I think, voluntary benefits that we see. And the last three are definitely not an inclusive list, but kind of just a way to get you thinking about, some of the different benefits your employer might offer. So there's been, especially with the pandemic, a lot of focus on what wellness benefits or wellness incentives employers offer. So this can look like EAP or employee assistance program resources, premium discounts for health insurance, mental health, first aid, something as simple as, doing a step challenge or, some sort of, workplace wellness initiative. Those are all sort of, great add-ons. Then we're seeing a rise in things like tuition assistance, professional development, continuing education for employees. Some employers will also extend that to the children or spouses of their employees as well. So looking at taking care of the whole family there. And then things like commuter benefits, that is spelled wrong, that's my bad. But commuter benefits, so, an RTD light rail pass or a stipend for working from home, free parking, where your off place of work is, things like that. But this is definitely, the sky is really the limit here. I think the organizations that really thrive with their benefit programs are the ones that look at what do my employees need? Is that having, options or discounts for daycare or childcare? Is it allowing people to work from home? Is it giving them a work from home stipend? What is going to keep people in the workplace? What do people really need? And what we've seen in the last 3-4 years, a lot of employers have really shifted in kind of those different add-on benefits for how they want to best support their employees and their families. Okay. I also wanted to touch a little bit on how benefits, some of the more traditional ones. So thinking about, 401k retirement plans or health insurance plans, so medical, dental, vision, life, disability, as well as some of those pre-taxed advantage accounts that I had mentioned. how those work, or what you need to be aware of at different stages in the employment life cycle. So when you're starting a new job, I know it can be very exciting, but it can also mean a lot of details that you need to remember when it comes to thinking about your benefits, how things are going to transfer over from one employer to the next and making that transition. So first and foremost, you want to make sure that you are a benefits eligible employee. So if you're working part-time or variable hours, or if your employer maybe has a little bit of a different definition of what benefits eligible means, based on the size of the organization, how their plans are set up. Most employers will default to the definition of a full-time employee or benefits eligible employee that's set out by the IRS and the Affordable Care Act, which says that you need to work at least 30 or more hours a week. Some plans are designed so that you have to work 32 or 37. So make sure that you understand, are you a benefits eligible employee or not? The next piece that you're going to want to look at is that waiting period. So are your benefits going to be effective, that first day of hire, or is it the first of the month following your hire date? So if you started work today, on April 25th, your benefits would kick in May 1st, or is it something more like a 90-day waiting period? Those waiting periods are at the discretion of the employer. So as long as it's somewhere between, your first day of hire and 90 days, there's a lot of variation on how that piece can fall together. So it might mean that, considering when your benefits terminated from your previous employer, maybe there's a gap, and we'll talk about that here in a second, from when your previous benefits end to when the new benefits start. So just understand what that waiting period is and what that might mean for you. Thinking about, once you are an employee, you're going to go through that annual open enrollment period. So especially when it comes to your health insurance plans, this is going to be your opportunity to make changes to your benefits. Think about, what's going to work best for you and your family. This is also when employers might update what they offer as well. So especially, if there are big changes that your employer is making, really take the time to ask questions. Most organizations will have open enrollment meetings. They might work with their insurance carrier. So like the Cignas, Blue Cross, United, organizations like that to help educate you on what your options are. So really take advantage of those opportunities during those open enrollment periods. Outside of open enrollment, if you do want to make changes to your benefits during the year, you're going to have something that's called a qualifying life event. So we can think of this as something, birth, marriage, birth of a child, getting married. Also, think about it in the reverse. So when you lose a family member or when you get divorced, unfortunately, those things are qualifying life events as well. And typically, when you do experience one of those qualifying life events, you'll have 30 days to let your employer know and make any changes that you would want to your benefits. So for example, if you get married, you'll have 30 days from that date of that event, so the date that you got married, to make those changes. Otherwise, you're going to have to wait till that annual open enrollment period every year. And then thinking about the end of our employment life cycle, separation or termination. So, just like how your benefits might have a different waiting period when you're onboarding, there might be different plans for termination as well. Some benefits will terminate, on your last day of employment. Some organizations will have their benefits terminate on the last day of the month where you worked. So if today was my last day at my job, my benefits would end on April 30th. The other thing that you're going to see at the end of your employment relationship with an organization is you're going to get notifications about COBRA. And COBRA is going to be a way for you to continue the coverage or the benefits that you had in place while you were employed after you have separated from the organization. So a couple of things to be aware of for COBRA. Similarly to how you have a qualifying life event, you have a certain number of days for when you can enroll in COBRA. So you need to, if you want to continue your coverage that you had while you were employed, you have to enroll in COBRA within the first 60 days of after you are separated from the organization. So you have 2 months. Maybe you're not sure if you have another job lined up right away. So this will buy you some time, and that coverage can go retroactive to your last day of work at the organization.
Just for sure, 'cause, I don't have a charger for a car.
The other thing to
And I'm
know
alone.
about
Like, I'm only on
COBRA
40
is that how you have to pay for it. So usually while you're employed at the organization, your employer might cover part of your premiums or cover the premiums. When you enroll on COBRA, you become responsible for 100% of that monthly premium, as well as there's usually going to be a 2% administration fee that's tacked onto that. So you want to be aware of, what that cost might look like for you once you're no longer employed by the organization. Maybe those benefits are so great, it doesn't, make a difference to you. Or, you might want to think about, other options available to you, maybe coverage through a spouse, individual options through the marketplace when it comes to health insurance. But lots of different considerations there. Hopefully this gives you a little bit of sort of a snapshot on some of the different considerations for, employment benefits at different phases of the employment life cycle. So that was all the content that I had for you today. I know we're going to hold questions until the end. But Deborah, I know you are going to be talking about separation and termination. So I don't know if there's anything that you wanted to add right now, or if you wanted to wait for your presentation.
I think we could probably wait for my presentation, and you maybe might want to add a couple more things after mine.
For sure.
Awesome. Thank you so much, Sonia. This was so helpful for me, even as a small business employer. Appreciate that.
Of course.
Well, hi, ladies. Deborah Yim here. Hi there. So nice to see all of you. And we were so glad that we were able to bring this presentation to you. I know this is our third and last time here for the year. And, from the beginning last year, we talked about, rights that you should be aware of before you start employment. And then in January, we were back for employment rights you should be aware of during employment. And I'm going to close it out with things that you should know when you're about to leave your employment. So how many of you ladies have actually left your workplace for whatever reason? Voluntary or involuntary? Let me see a show of hands. Looks like we got quite a few of you. And and if you haven't left yet, probably sometime in your career progression, you will. So we want to just give you some education about some of the things that you should be aware of. And there's just so much. I mean, there's a whole book, about these kind of issues, but I have to cover it in about like 10 minutes or so. So this is just going to provide you a really basic checklist that you want to just kind of look through. And a lot of the stuff is really complicated. And so you might need to do more research. You might need to reach out to an employment attorney. But I just want to give you enough of a flavor where you can kind of go, okay, this doesn't smell right. I need to see an attorney. Okay. And so if we accomplish that today, then I'm happy. Okay. So just keep in mind, if it's a little confusing, it probably is, and you probably will, need to get more information, but it's just enough for you to catch that concept and say, okay, you know what, there's something wrong here. Okay. So let me screen share with you a little bit. And let me see if I can get that. Okay. Can you all see my screen by any chance?
Yes.
Okay, and I'm going to hit let that be the from the
A
beginning.
little bit of your head's cut off. Just a little bit.
How's
Of
that?
your hairdo.
Deborah, I don't see your slides. Is that what you were?
Yeah, can you see my slides?
No.
No,
You just see your face.
we see you.
Oh, give me 1 second. Let's see. How about that?
Nope.
Just you.
Oh, okay. Technical difficulties. Let me try again. Oh, how about that? How's that?
Yep.
Can you
Yes.
see
There
that?
we go.
Yeah.
Yep.
Okay. And you just see one slide, right?
Correct.
Now
Okay.
we see the presenter view.
Oh, okay. Oh, how am I going to do that? Let me. Oh, here we go. How's that?
Perfect.
Okay, great. And I have to say that my slides are not as pretty as Sonia's with no graphics, but I just wanted to get you, and I will share these slides with you after the presentation as well. So don't worry about taking notes or anything like that, okay? So when it's time to leave your job, things to know. And just to share a little bit about myself, I am an employment attorney as well. I represent mainly employees, individuals who've been discriminated, harassed, or retaliated in the workplace. And I do some consultations for small businesses who want to prevent lawsuits from happening. So we do like employee handbooks and things like that. Prior to opening up my own law practice, the Primera Law Group, I was with the United States Attorney's Office, as well as the United States Department of the Interior, where I represented management and supervisors. So I've kind of been on both sides, representing both employers and employees. So it kind of gives me a good perspective whenever a lawsuit comes around. And I have to say that after I opened up my law firm in 2020, one of the things I always worried about was whether I'd have enough clients. And that has not been an issue because, you know, employment law is something that's so pervasive. And unfortunately, people get fired and suspended all the time wrongfully. And that is when they need to go to an employment attorney. So it's not been an issue about having clients, but it's a pleasure to be here talking to you today, and I hope to share some knowledge with you. So today I'm going to discuss with you 3 topics: termination versus resignation. Those are 2 different types of separations, an employee checklist upon separation, and when you have an employment claim. How do you know when you have an employment claim? Okay. So first thing, separation. There's 2 types. One is a termination. That's when you're being forced to leave. Essentially, when your employer is, you know, forcing you to go. That could include a layoff or a downsizing. And a resignation is when you voluntarily leave for whatever reason. That's called a voluntary separation. Okay. There's a note here for a constructive discharge. That's when the working conditions were so intolerable that a reasonable person would have to quit. And that is treated by the law as if you're being fired. Okay. So sometimes I get questions from clients that say, well, you know, if I quit, that means I can't file a lawsuit for discrimination, right? And the answer is no, right? That means that you know, you can file a lawsuit if it's gotten so bad and it's so intolerable. It's treated as a firing under the law. Okay. It's treated as a termination. It's a very high standard to prove this. So I would say be very careful, maybe talk to an attorney before you make a decision to quit for this reason. And if you resign, one thing to know is that it might be harder to get unemployment benefits. Question I get is, you know, should I resign? And so some of these questions is what I often ask, you know, like if you're making that decision where it's like it's so hard for you to get out of bed in the morning to go to work, because it's just, you can't even stomach that idea, right? It's almost like the smell test. It's gotten so bad that you can't stomach going into work for another day. Some of these examples of when it's so bad: discrimination, harassment, retaliation. Some of the other attorneys before me that I've chatted with you went over some detail of, you know, when this is, when there's discrimination, harassment, retaliation. When you're being forced to take part in fraud or criminal activity, when your employer won't reasonably accommodate your medical conditions. So these are some of the things where it's gotten so hard that you can't even bear to go into work. Okay. It's, like I said, very high standard, but that's something you should consider. Is your doctor recommending you to quit your job because it's detrimental to your health? I've had a client where she had, you know, mental health issues, and going into work caused her to have suicidal ideations because they continued to heap discrimination and harassment upon her. Right? If you can get a doctor that says, you know, you shouldn't go in anymore unless they, you know, change their ways or they provide you accommodation, that's something to consider. Do you have another job lined up? Are you able to wait to find another job before you quit? You know, obviously these are financial concerns that you might have at quitting. So that's something you want to think about. And the last thing to consider is, do you have to repay your employer if you quit for any training, education, or relocation expenses? Okay, so those are some of the questions you might consider if you're thinking about resigning. A caution I like to put in here is sometimes the employer is a little sneaky, and they'll call you into the office and they'll say, well, you can either quit or we'll terminate you. And that's not really a choice, right? Most everybody would choose to quit. Otherwise, you would have to say to your future employers, I was terminated. So it's basically no choice to you. And so when you're filling out things like unemployment, you want to make it clear that you only quit because your employer forced you to, right? You would have been terminated otherwise. And so it was to you basically an involuntary resignation. Okay, so that's something to keep in mind. The employee separation checklist. So these are some things where I pull this list out. If you're terminated or you're thinking about resigning, here are some things that you might want to check off. So your reason for termination and or separation. Say you get called into your office, into the office, and the employer HR says you're being terminated, right? You have a little typo there, but you can certainly probe, okay? You don't have to be afraid to probe and ask why you were terminated. The employer might refuse to do so, but in Colorado, it's required to fill out now, actually with the new law that's passed, you have to fill out a notice and unemployment benefits form, which indicates your reason for separation. In the past, a lot of employers just say, well, I don't have to give you a reason for termination. The reason is no reason, right? We get a lot of those. And you should be pretty adamant and sit there and say, no, you're required under law to provide a reason for my termination. And if you don't want to give it to me verbally, put it in the notice of unemployment benefits form. You can even ask for a termination notice, because you don't want to change them to change the story afterwards if you have a case, right? So get it in writing if possible, and don't be afraid to probe. I'll make sure I change that little typo on the PowerPoint. Resignation. If you're being forced to resign because of bad working conditions, you could also put this in writing so there is a record of it as well. But it's optional and it depends on your circumstances. If you don't feel, if you're still there at work and you're uncomfortable, you could do it after you leave. A common question I also get is the exit interview. This is something that HR, departments like to do. They bring you in and they say, oh, we'd like to have a little, conversation with you about why you're leaving. Keep in mind, you're not required to do this. It's optional. Oftentimes as employment attorneys, we tell our clients don't do it because sometimes you say something in there that you probably shouldn't say, or you say too much. So that's just something to keep in mind. You don't have to do this. Very big thing, make sure that you check your employment agreement and your handbook. A lot of you might have come into employment if you're working for a small business and they don't have an employment agreement or handbook, okay? But if you're working for a big employer, most will have you sign an employment agreement, and there'll also be an employee handbook. A lot of them will have terms in there regarding resignation, regarding termination, regarding separation. So make sure you check and see what those terms are. Read them very carefully. Now, even though Colorado is an at-will state, which means that they can fire you for any legal reason, the employer might just give up some of their rights via an employment agreement because maybe they just are so excited about you as an employee joining, they're willing to give up some of their rights, okay? They might say, we can only terminate you for cause or for a good cause, right? So for example, that could mean poor performance, if you lose your license, if a license is required for a job, if you're convicted of a crime or you embarrass the company. And sometimes the employment agreement or the handbook will indicate what will happen for a termination versus a resignation. It might even set forth the terms, like the actual time period of your employment. Could be 3 years, 2 years, etc. They can't fire you before then. It might even set forth things like severance upon separation, a payout of bonuses and commissions, a notice period that you have to give, confidentiality. So really, really important. I cannot stress it enough to please check to see. Sometimes you've been maybe employed with the same employer for 10 years, right? And you forget if you have an employment agreement, check your emails. You know, when we first came to speak with you ladies, we gave you a portfolio to put in all your important employment documents. Please make sure you keep things like your employment agreement, email it to yourself, keep it. That is so important because sometimes the employer loses that document as well. All right, so please check that. Please keep copies of that. And upon termination or resignation, check to see if some of these terms might apply. One of the terms that is often put into employment agreements is a non-compete and a non-solicitation clause. And if you have this, I would, strongly urge you to read it very carefully and perhaps consult an attorney, because some of these are not legal in Colorado unless applies to highly compensated employees who meet certain salary requirements, right? And that salary requirement would be 101,000 plus for non-competition clauses and 60,000 plus for non-solicitation clauses. So generally, I would say, in your situations, it's probably not going to be legal. And if it limits your ability to go and find another job in the same industry, be very careful about this and check your rights about that, okay? And if possible, negotiate this away before you leave your employer. Now, the rest of these checklist items are applicable if you don't have an employment agreement. I would say look at these, more carefully. If you have an employment agreement, sometimes they give you very specific information about things like notice, okay? But if you don't have an employment agreement, consider some of these terms as well. So think about what kind of notice you want to give your employer, or what kind of notice you want to get potentially from your employer. So notice is essentially the time period where, you tell your employer, well, I'll give you an additional period of time for me to stay here and help transition your new employees, or to help you with basically transitioning to the next person. 2 weeks is generally customary, but it's not required generally. And if you're being terminated, don't be afraid to ask for a notice period, right? They might say, well, we'd love for you to leave right now. And you could certainly ask, okay, you know what? I'm going to need at least 2 weeks. You're terminating me very suddenly. So don't be afraid to ask for that if you need it. If you're part of a mass layoff under the WARN Act, there's a 60-day notice period required, okay? And this is generally for big companies that have 100 or more employees, and they're terminating like 50 plus employees within a site location, and 33% of that site. So something to keep in mind. And again, I say check your employment agreement for any details regarding notice periods. Remember that the employer can ask you to leave sooner or put you on something called garden leave, okay? And garden leave is essentially saying, I'll keep you on my payroll, but you do not need to report to work anymore. I don't want you coming into my office anymore, because they're often afraid that you're going to try to take important documents or destroy certain documents, et cetera. So they might put you on something called garden leave. So before you give notice, make sure that you have everything printed out that you need before you might get locked out of the computer system, okay? This is something that a lot of clients don't think about, they just give notice and then they're just walked out the door. So something to keep in mind is, if there's any important documents like pay stubs, your awards, your evaluations, warnings, things like that, if you need it, oftentimes they're sent over to your work email account, and we're so busy sometimes we don't forward them back to our Gmail accounts, or we don't print them out. This is your last opportunity before you give notice to try to print everything that you need. Let's say you think that you might have an employment case for discrimination, retaliation, harassment. Try to print out all the documents that you need to support your case. If you have any important personal items in your office, your cubicle, your cubby, make sure you want to take some of those things home, because if you're walked out early, I've had situations where the employees walked out immediately upon resigning, and the employer says, oh, don't worry, we'll send you your personal belongings later. Some of that stuff never goes back to the employee. And important like keepsake items are all gone. So remember, before you give notice, slowly take some of those things home. And then a caution to you is that you might be monitored. I've had situations where I've actually been in a situation where I was meeting with management and the IT person comes running into the office and says, hey, so-and-so is copying all this material and forwarding it to another email account. And the president of the company says, shut that down immediately, right? So something to keep in mind, you're being monitored. And especially after you give notice, they're going to be watching you very carefully. And keep in mind as well that, there's certain things like trade secrets or proprietary information of a company that you are not allowed to take. So before you print or take anything, keep those things in mind. And then a practical tip is a lot of us check our personal emails at work, like our Gmail or Yahoo or Hotmail. Make sure that you lock and sign out, lock yourself out of those accounts and close out those accounts, exit, sign out of those email accounts so that your employer cannot look at them. Okay. References is something that is always very important if you're looking to the next job, future employers. Find out what your employer's policy is on references. Do they do neutral references? A neutral reference is where essentially all they provide is your name, your position, and your dates of employment. And that is something that's very common now. Employers only do that so that they don't get sued for anything they say in the reference. So, find out what their policy is. See if they'll give you maybe even a positive reference letter if you want something like that, and try to get it before you leave. Feel like after you leave, they don't feel as obligated anymore towards you. So try to do that if you can before you leave your place of employment. Your personnel file. That's something we don't often think about, but you're entitled to review your file at least once a year and at termination. Get a copy of your personnel file before you leave as well. Have that handy because you never know when you might need that again. Okay, and that is under the law. They are required to allow you to look at your personnel file at termination. Make sure you update your contact information. That's something that, sometimes in the rush to leave, you might forget to do. And HR is supposed to ask you for that, but if they don't, provide your current address and your phone number and provide in writing where all notices and your final paycheck should be sent. Your final paycheck. Law in Colorado is very clear. If you're being fired, the employee has to pay you your final paycheck immediately, or as I said here, if the employer's accounting department is unavailable, then the final paycheck is due within the first 6 hours of its next regular workday. And then there's another exception, therefore, if the accounting department is offsite. If you quit, the employer must pay the final paycheck on the next regular payday. And also make sure when you get your final paycheck that the employer is not making improper deductions from it as well. The other thing to keep in mind is that you get a leave payout. Okay, not only do you get your final paycheck, you should also get a payout of any unused vacation leave that's accrued by you. So it's no more use it or lose it. In Colorado a couple of years ago, it was use it or lose it, but there was a Supreme Court case that came out and said, no, you need to pay it out. Okay, it got to be cashed out to you, regardless of whether it's a termination or resignation. Sick leave does not have to be paid out, but nowadays, a lot of the employers combine sick leave and annual leave, vacation leave, in the category of PTO, and then they have to pay that out. Check your employment agreement as well, because your employer might have contracted to pay out more than just vacation leave. Severance. This is not required, but some employers will offer that to you. And if they offer that to you, I'd be very, very cautious and wary. Because oftentimes they're going to ask you to release any legal claims against them. Basically, you're going to promise not to sue them, okay, for anything that happened during your employment. We'll give you 2 weeks of pay if you agree not to sue us for anything that happened during employment, okay? Before you sign anything like this, please evaluate it very carefully. Consider hiring an attorney to just review it. Don't just sign it. I had a lot of people that just signed it. They didn't know what they were signing. They just thought, oh, is this a severance agreement? Is this extra money for me? They didn't realize they were signing away their rights, and I couldn't do anything for them, okay? Because once you sign, you release, you won't be able to sue your employer anymore. Now, If you are 40 and above under the ADA, you get more time to review and change your mind. I think it's 21 days and then 7 days to revoke it. Okay. But again, very, very important. If you're getting a severance agreement, please read it and please, chat with a legal expert about it. You don't want to sign away your rights. Another question I sometimes get is, if you quit, can you ask for a severance? And it depends on your reason. Are you quitting for a good reason? Was it a constructive discharge, essentially? I don't think it hurts to ask. But again, keep in mind, you'll probably be asked to release your rights to sue your employer. So make sure you're aware of that and you're willing to do that before you sign. And again, it might impact your ability. If you do collect severance from your employer, it might impact your ability to get unemployment if you're not releasing any claims. So keep that in mind. Make sure you return your property and take your personal belongings. If you fail to return your employer's property, keep in mind that the value of whatever property, like example, a laptop. A lot of us are working remotely now. Employers give you a laptop, you don't return it. The value of that could be deducted from your final paycheck. Make sure you take back all your personal belongings. Again, do not wait to come back if possible. Sometimes you'll never get the stuff back. Ask for all information regarding benefits continuation. Sonia gave us some really good information about some of these benefits. So ask about it before you leave, okay? And who's the contact? Who's the person that you should talk to get some of this stuff? COBRA, health, life, disability, insurance, and retirement. And don't forget to apply for unemployment benefits. Even if you're not sure if you qualify, apply for it. Don't wait, as it will take time for the DOL to get to your file. And one thing you could do is talk to your employer, see if they'll agree not to appeal or object to your unemployment application. And keep in mind that benefits will last up to 26 weeks pursuant to a statutory formula. Now, do you have an employment lawsuit? So after you deal with all the, this entire checklist, something in the back of your mind should be, well, am I leaving because they're forcing me out for an illegal reason? Are they terminating me for an illegal reason, an unlawful reason? So some of the questions you might want to ask are, was there discrimination, harassment, retaliation? Was there whistleblowing? Did you complain about working conditions, poor working conditions, safety conditions, and then you were fired? Did you complain about a violation of the law and then you get fired? Was there a breach of an employment agreement? Were there certain terms that the employer agreed to in the employment contract and they failed to comply with those? Did the employer not even have a good reason at all to fire you? Did the employer fail to properly pay you or fire you for following the law? Or is your employer bad-mouthing you to prospective employers? That's a defamation claim, right? So that's where the references come in. If you answered yes to any of these questions, you might potentially have an employment law claim. And so, feel free to contact an attorney to check that out and get a consult. Now, one thing to remember, though, very important, that's why I highlighted it, is there are deadlines for going to the EEOC, the CCRD, and filing a lawsuit. For a discrimination claim, you can't just go to file a lawsuit right away, okay? You have to get an administrative charge filed first with the EEOC, federal, and the CCRD in Colorado. And there are some important deadlines. So for example, if you were terminated by a small business employer, under 15 employees, you have 180 days after you were terminated to file your charge of discrimination with the CCRD, okay? If it's a big employer, then you have 300 days. Very important to keep in mind, if you miss these deadlines, you will probably be out of luck on your discrimination claim, okay? And then once you get a right to sue from these agencies, you have 90 days to file a lawsuit in court. That's another thing to keep in mind. And I think that's all I have, but if you have any questions, I've put my contact information here and you can feel free to reach out to me and I'll share this PowerPoint as well. Any questions? Either for me or Sonia or Lilium?
Can you put that slide up again for your contact information?
Yeah, sure. Hold on. Let me go back to that. Can y'all see that?
Mm-hmm.
Just a
Perfect.
minute. 308. Oh, pen right. 67. 3. Yeah, I
If my
got
video
a little
stopped.
comment. I've got a little comment. This has just been wonderful. I've spent like 30, 35 years in the tax business, and people will come in when their tax is done and all sorts of things, and they'll be talking about their work. And I tell them, you know, whenever you go to a new job, you take that employee handbook.
Mhm.
You write the date down that you got it from HR and the dates you read the different parts of the book to complete reading the manual. And I said, it's just like your college catalog, which has your things down for your major listed in there. And you should be doing the same thing with that so the school can't pull anything, and then take them down to put them in a safety deposit box just for safekeeping, because it's so easy to automatically actually throw some old book out. You know what I'm
Yeah.
saying?
Definitely,
So
definitely.
I always mention them to that about that. The other thing that I did mention to people is that if they are leaving and with a COBRA that is offered, if the employer, I don't know, things may have changed now in the past 2 to 3 years since I've been sort of out of a lot of stuff because I've been sick. But anyway, I would also tell them when it comes to COBRA that if the employer has to offer that to you, and if they don't, there's only 2 ways in Colorado, one's a federal and one's a state, is that the only reason they cannot offer that to you is if there was a threat made to the employer and they don't want you coming back on the property to make the payments. But they will work things out for Medicare supplementals or something with your other insurance. They're a lot of times they're really willing to and able to help you with that too. So the premium isn't as big as you think it is.
Thank you
And
so
I'm
much.
so
That's so
glad you
helpful.
covered all those things. But you know, when people come in and they get nervous, so I sort of do those things to calm them down when they're looking for another job or whatever, you know, or can I deduct this from my taxes or whatever. So I don't
Thank
know
you
if
so
it's
much.
still
Yeah.
correct or not. I don't know if it's still correct or not, but
Yeah, something that I also recommend is now a lot of things are electronic, right? Back in the day, when I got my first job, it was like they hand you a folder, there's like maybe a stack of documents that you have to sign, and they're all in hard copy. But now a lot of things are DocuSign, they just email it to you, to your work account, and then you just like sign it, right? And then oftentimes we get busy, we forget about that document that was in our work email. I would say, try what I encourage my clients to do is open up a separate like Gmail account. It's free, right? Open up a Gmail account and have that dedicated to your work issues, right? Because you can, let's say something happens at work and you need to do a log, right? Open up your email and send an email to yourself. It has the timestamp on it, right? Of, when you send it back to yourself. But that's a good way to take notes. That's a good place for you to forward like all important employment documents, right? If it's virtual, if it's like an electronic copy, like your employment agreement, forward it to that Gmail account, right? And that way you can have access to it. So when you leave, everything's in this nice Gmail account that's just solely devoted for your work issues. So I definitely recommend that so that you can keep, because there's so many situations where the clients just don't have anything. They never thought they would ever leave. They never thought they would be fired, and it happens so quickly. So definitely keep track of those documents.
Any more questions from anybody? Comments? Fabulous presentation. Really good information. Thank you, Lilium, Deborah and Sonia. I mean, this was really good. And a lot in the chat has been, how do we get the slides? So would you be able to share the slides? And then I can send them out to all the attendees here.
We can definitely do that. I'm not sure that the first two presentations from January and last year had any slides, but I will double check with them.
Okay,
But we
great.
can certainly send the ones from today.
All right, excellent. Very, very good. So I guess, that kind of wraps it up. Well, no, it doesn't. Actually, it doesn't. Sorry. It doesn't wrap it up. So I'm going to now pass it over to Amra, our executive director, and she's going to talk about the upcoming programs that are for you. So.
Good evening, everyone. I hope that you enjoyed that information. I do want to take a quick second and really thank you, Deborah, for coordinating all of this. This is truly amazing. You all have dedicated 3 separate meetings, like 6 hours, and not even the amount of hours it took you to prepare these presentations. We truly appreciate this information. We couldn't buy the information that you have shared with the members of our professional women's group. And we really just want to thank you so much for having a concern for the women and understanding their rights. And so everybody, can we get a hand clap? Can we get finger snaps? Can we get thumbs up? All of the above. We are so grateful to you for helping us out and for teaching us so much valuable information. All right, so I'm going to roll into announcements now. Got a couple of announcements for you. All right, so that's our table topic. We don't need that anymore. Next, or welcome. We have already welcomed. Excellent. Very important, everyone on this call, and if you know anyone, this Thursday evening, we have our Mac and Trish McAvoy class. Registration is closed. We have exceeded the amount of women who can attend this class. Also, please keep in mind, the first 70 attendees will receive a gift. That means if you are not the first 70 attendees, you will not receive a gift. Please understand, we were given a specific amount of gifts, and so all we have is 70. So you want to make sure that right at 6:30, when it starts, you have got to log in. You can't wait. You cannot be late because it comes in the order that you log in, and we will be able to provide a gift for the first 70 attendees. Even if you have to come in late, you're welcome to attend. You're welcome to get the information. I think it'll be valuable.
Get a plate, baby boy, food is ready.
Oh. Somebody's talking. Make sure to keep your lines on mute. I'm almost done. Give me like 5 minutes. It'll be valuable information. It'll be wonderful, but please keep in mind, only the first 70 attendees will receive a gift and registration is closed. Next, we have a wonderful scholarship opportunity. We partner with a staffing organization called ADECO, and they have opened a partnership called a COTIS Academy. I know it's a crazy name, but a COTIS Academy is to provide digital literacy training for women as well as employment opportunities. The cool thing about this program is a virtual program, so it's online. It's at your own pace, self-paced. We have the ability to scholarship one person into this program. The best part about it is once you finish the training, you have 3 separate options here of employment. So they can steer your training toward a business or a data analyst. They can steer it toward project management, or they can steer it toward an IT help desk. ADECO is one of the largest staffing agencies in the United States. And I mean, United States, it's actually global, but they're focusing on the United States. If you have ever wanted a job in this field, if you presently have a job in this field, but you want to get some more training so that you can continue to be successful, I strongly encourage you to apply for this program. I will be taking applications. All you have to do is let me know that you want to attend, and you and I can schedule a call. We can chat about it and I can get you going. It's not a long application process, but I have one scholarship to give. So please, that is my email address down there. Please reach out to me as soon as possible, and we would love to get you going in this class. Next, on May 16th, Jewish Family Services is having a job fair. They have some wonderful employers that they have partnered with. They are also going to be doing free LinkedIn headshots during the 10:30 to 12:30 timeframe. So if you are looking for a new job, if you know someone who's looking for a new position, this is a wonderful opportunity. Employers are there with jobs on site. So they will be hiring, and you notice that last part, dress to impress. That's where it comes in with us. You definitely want to dress to impress. So if this is something you're interested in, definitely come see us at our next suiting. You can schedule an appointment, or you can come to this Saturday from 10 a.m. to 12 p.m. and get a nice refreshed outfit to go for this job interview. On May 4th, Kelly is back doing meditation. So as you've noticed, we've taken meditation from monthly down to quarterly. So she will be doing a meditation on Zoom next Thursday from 6 p.m. to 7 p.m. She is also doing something really cool. She's doing a drawing to provide personal meditation coaching for someone who attends the class. So she will be doing a random drawing for anybody who is participating in the class. This is really cool because this is a $350 value. She is your meditation coach. So you tell her what you need, you tell her what your goals are, and she will craft a meditation program with you and do it with you, which is pretty cool. Also, by attending this class, you will receive one piece of clothing. Finally, this Saturday, April 29th, we are open from 10 to 12. I apologize, it says 2 there, but that's really 12, I promise, 12, for you to redeem your suiting coupons. If you need an appointment during the week, that's not a problem. You can call Jennifer, or you can send her an email and schedule an appointment. Finally, Anne, would you like to close us out tonight?
So let's close by speaking together. We go forth with confidence, courage, and belief in ourselves. Thank you, everyone, for coming. And I hope you got great value out of this evening. It sure seemed that way. It was amazing information, as I had said before. And, feel empowered from that. So once again, thank you, and see you all next month.
Thank you.
Thank you. And to answer the question in the chat, for the meditation on Thursday, we will be sending our newsletter out by next week that will have that link in there. And we would love to have you join us. So everybody on this call will get that invitation with that link. I think there's another message. Can you please? Oh, I'm going to put my email in the chat for the scholarship. I would love to speak with you about applying.
What time can you log in for the makeup?
You can be logged in early, and the class starts at 6:30. So if you go ahead and just sign in at 6:15 or whatever, and then as soon as we start the class, we'll just pull people through.
Hey, wonderful.
Yeah, it's very exciting. I love these types of things where you get the virtual makeup class. I think it's going to be a whole lot of fun.
Super.
Okay. Thank you, everyone.
Thank
Have
you,
a
everyone.
wonderful, wonderful evening.
Thank
Thank
you.
you.
Thank
All
you.
righty. Bye-bye.
Okay.
Bye.
Bye-bye.
Bye-bye, and thank you.